Hi there, I'm James Dapperchi, and this is Coffee in the Case Note. Today, team, Section 1318 of the Corporations Act and excusing the breaches of directors and some other natural persons related to companies. 1318, what is it? How does it work? 1318 grants the court the power to excuse a person from liability in respect of negligence, default, breach of duty, breach of trust, if this person was honest, if the court thinks the person ought fairly be excused from liability, and if the court wants to exercise its discretion to do so. It's a little bit mechanical, and we're going to work through it again, so please don't worry at this stage. But the whole point of the section, as you may be able to tell from that quick explanation, is to allow honest, hard-working directors and other officers who are making decisions to run a company to be excused if the goofs they've made, and when I say goofs, it means an actual breach of trust, an actual breach of duty, so perhaps it's a little higher than a goof. But if we call it a goof for the sake of this conversation, it allows those goofs, notwithstanding the fact that they have indeed happened, trust has been breached, duties have been breached, it allows the liability that arises from those breaches to be within the court's power to excuse or partially excuse. So it's an interesting section to use when you're thinking about advising your director client who may have liability or who may want to make an application in relation to future liability. The 1318 is a good one to bear in mind. So today I thought we'd work through a quick case study on how it's been applied in the past. Might help you out. Hope it does. Right. We've got a company director, and the company itself is operating a football team. The company withholds tax from its employees, but does not go on to pay that withheld tax onto the ATO. And as you can well imagine, the ATO found that very interesting and presumably commenced all sorts of proceedings, but one of these sets of proceedings that commenced was against the director personally. And this was on the basis of one of the sections of the Income Tax Assessment Act that allows the ATO to go chase the director of a company in certain circumstances if withheld tax is not paid. So essentially the ATO sues the director for the withheld tax on the basis that the director has breached this part of the ITAA. Right. District Court, first instance. The District Court judge says, very interesting ATO, but accepts the director's 1318 defence. Right? So the ATO makes out its claim. The court says, yeah, fine. And the court then turns to 1318 and says, well, this is either negligence, default, breach of duty, breach of trust. This director has acted honestly. This director ought fairly be excused. And in the circumstances, the court will exercise its discretion to reduce liability to zero. Right. The ATO appeals and, in short, wins. The reason the ATO wins on appeal is that Section 1318 is applicable to, what did I say? Negligence, default, breach of trust, breach of duty. But it does not operate to contradict the terms of the Income Tax Assessment Act. And so three very serious appeals court judges click through the interaction between the Corporations Act, where we get 1318, and the Income Tax Assessment Act, and say that it cannot be the case, they find that it cannot be the case that 1318 can operate to excuse a director's breach of the Income Tax Assessment Act because of the way those two pieces of legislation interact. Right? So this director was honest, but the breach stayed with him, liability stayed with him, because 1318 does not operate for that section of the Income Tax Assessment Act. Right. That's a little fiddly issue. What I really would like you to take from this discussion, if anything, is that Section 1318 has a broad application and it can really help these directors and officers and other parties associated with the company. You can go have a look at the section to see what those parties are. And it works in a significant number of areas, including the list that I did my best to memorize this morning that we went through earlier. What do we have? Negligence, we had default, we had breach of duty, we had breach of trust. And that if the court finds that the relevant person acted honestly, if the court finds that relevant person ought fairly be excused from liability, then there's every chance it may well be excused. He or she may well be excused, but not in the case of this particular breach of the Income Tax Assessment Act. So thank you for joining me on that adventure through the exciting corporations and taxation legislation. I look forward to joining you for another coffee and another case note real soon. Cheers.